Can the Appellate Division reverse a SORA adjudication and then allow the prosecution to make an upward departure argument for the first time on remittal? To find out, you have to read People v. Weber, but it's 32 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, New York Court of Appeals cases that I try to cover, if I can, in 5 minutes or less. This is the episode on the case of People v. Weber. The index number of this case is 2023, New York Slip Opinion 03301, published by the New York Court of Appeals on June 15th of 2023. The issue in this case is whether the people, the prosecution, is allowed to make an upward departure argument in a second or subsequent SORA hearing after it's remitted from the Appellate Division. To understand what's going on and what that all means, there's two things you have to understand. First is a general basic background of what SORA is. SORA is the Sex Offender Registration Act. It's not a criminal proceeding. It's basically a civil, or it's sort of a quasi-civil administrative proceeding where the court has to determine the level of risk that a sex offender, a convicted sex offender, poses to the public. And they do this, there's a whole procedure laid out in New York Corrections Law 168, where what happens is the Board of Examiners of Sex Offenders, which is a group of professional mental health experts, have a risk factor list, like a checklist, a risk assessment instrument. And they go through the checklist and they come up with a presumptive risk level. They say risk factor 1, the defendant gets 10 points. Risk factor 2, the defendant gets 5 points. They go through this whole list and they present to the court and to the parties this risk assessment instrument, which has a presumptive risk level. And that presumptive risk level, the points, line up with a risk level 1, 2, or 3. 1 is low level, 2 is medium level, moderate risk, and 3 is high risk for reoffense. Less than 70 points is presumptively risk level 1. From 70 to 110 is risk level 2. And 110 or more is risk level 3. And then there are overrides that apply that presumptively make it a risk level 3 if they apply. And ultimately here, either side, the people, which is the prosecution, or the defense, can then say, well, judge, I think the presumptive risk level doesn't adequately or accurately portray the risk posed by the sex offender to the public. And they can ask for an upward departure, which is what the people would ask for, saying, you know, the defendant I know the presumptive risk is 2, but really he's a high risk, so it should be 3, and I'll show you why. Or the defense can ask for a downward departure, saying, I know the presumptive risk is 2 or 3, but it really should be 1 or 2, and they can explain why. That's the general rule for sex offense. That's the SORA hearing in brief. And the second thing you have to understand, basically, a little bit about, is what an appeal is. An appeal basically is from an aggrieved party, a party that says the lower court's decision was wrong and it hurts me, and I want relief from that wrong decision. And generally, the general rule is only an aggrieved party, a party that's been aggrieved by the decision, by the error, can appeal and get relief. Okay, so now having that little background here, what's the facts here? The facts are, in 2014, there was a defendant who was charged with various sex crimes as against a 10-year-old child, and he pled guilty to sexual abuse in the first degree. Now he convicted sex offender. He has a SORA hearing, and at that hearing, he was adjudicated. He was given, the risk assessment instrument was prepared, and the risk assessment instrument gave him 110 points, which is 3, level 3. And it included, importantly for this case, he got points for risk factor 1, which is forcible compulsion. At the hearing, so he's presumptively level 3, and the defense says, Judge, I want to dispute the points in risk factor 1, and I want a downward departure because that doesn't adequately or accurately portray the risk the defendant poses. The judge heard the arguments. The people never asked for an upward departure because he's presumptively level 3. And the judge says, no, I find he's level 3, and it goes to the Appellate Division because the defendant appeals, and they say the judge was wrong. Risk factor 1 should not have been applied. So actually, he's presumptively a level 2 because it took away points. And here's where it's interesting. Here, the judge, the Appellate Division panel says, we're going to send it back to the court, back to the county court, so that the people have a chance, an opportunity to make an argument for an upward departure, because now he's not a level 3 presumptively, he's a level 2 presumptively. So they send it back to the county court, and the defendant says, this is all wrong. The people shouldn't have a second bite at the apple. At the second SORA hearing, the people asked for an upward departure. The judge granted that application, heard the arguments and adjudicated the defendant level 3 again, based upon the upward departure. The defendant appeals this, says this is all wrong, goes to the Court of Appeals, and that's this case. And the majority says that the Appellate Division was right. The Appellate Division properly sent it down to the county court because the ultimate goal is to provide an accurate determination of the risk the defendant poses to the public. I know they say basically, yes, in general, a criminal and civil case, they don't get a second bite at the apple. The party you don't get a second chance to make this kind of arguments. Every party has to basically make all their arguments on the front end, arguing the alternative, arguing for alternate relief, but they didn't do that here, the people. And they say, but this is unique. SORA is unique. And they say, this is the quote, or basically this is what they say is, curbing the power to remit, basically not letting the Appellate Division send it back for consideration of a departure request when the Appellate Division disagrees with the hearing court's assessment and changes the presumptive risk level would undermine SORA's objective and would constrain the Appellate Division's authority. So they say this is okay. The Appellate Division can send it back to the county court to allow the people to make this argument. But there's a very strongly worded dissent here, just by Judge Wilson. And he says that the general rule should prevail here. The general rule, the adversarial system requires that your parties, that the people make every argument they're going to make on the front end, that they can't not make the upward departure argument just because he's presumptively level 3, because they have to consider the possibility that this might happen. The Appellate Division might reverse on some of the factors. So they say that the general rule that all the arguments should be made in the first instance should apply here. There's no exception that should be made here. And yes, the people didn't make that argument, but that's their fault. So the general rule is, from the majority, this is okay. But once again, just be aware that Judge Wilson, the chief judge, says that the general rule should apply here. And as a technical matter, the people are getting relief, even though they're not the aggrieved party here. That the non-aggrieved party, which is the people who got everything they wanted by the trial judge's order, are getting some special relief here, which is not okay. And that's the case of People versus Weber. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.